On May 6, 2009, a group of 200 migrants and refugees who had departed from Libya aboard 3 rubber vessels towards Italy were intercepted by the Italian Coast Guard on the high sea. The Italian Coast Guard seized the vessels and detained the passengers on their ship. A couple of hours later, the passengers were brought back to the port of Tripoli, where they were handed over to Libyan authorities based on a bilateral agreement on migration control between Italy and Libya. 24 of the passengers, 11 Somali nationals and 13 Eritrean nationals, subsequently pressed charges against Italy before the European Court of Human Rights on May 26, 2009. The subsequent ruling by the European Court of Human Rights in 2012 is widely regarded as a landmark in international human rights protection with regard to migrants and refugees. In the following, we will try to understand why. In doing so, we'll give special attention to the notion of jurisdiction in international human rights law, the principle of non-refoulement in connection with the violation of Article 3 of the European Convention of Human Rights, and the prohibition of collective expulsions of aliens.
Any case that is brought before the European Court of Human Rights has to fall within the scope or jurisdiction of the European Convention on Human Rights. The scope of the Convention determines who can claim a right against whom, where, and to what extent. We will take a closer look at the jurisdiction criteria of the Convention to try to understand what made this case special. Article 1 of the European Convention on Human Rights states, "The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this Convention." At least 3 elements need to be distinguished here. First, the temporal scope, second, the personal scope, and third, the territorial scope of the jurisdiction. As to the temporal scope, meaning that the act in question has to be committed after ratification of the Convention by the respective states, jurisdiction is no concern. The personal scope determines whether the defendant is eligible to be judged by the court and whether the applicant has a right to claim against the defendant. Italy, being a state party to the European Convention on Human Rights, clearly submitted itself to the jurisdiction of the court. Moreover, the Convention clearly states that the state parties have to observe the rights laid down in the Convention with respect to anyone within the jurisdiction. This includes nationals but also aliens, irrespective of the legality of their presence. The controversy arises in the last section, the territorial scope. The court reminds that, as a rule, the jurisdiction of a state within the meaning of Article 1 is essentially territorial. This means that the extraterritorial application of the Convention outside of the state's territory is not generally foreseen by Article 1 of the Convention. In this case, the applicants were in the high sea and not on Italian soil. As the court continues to explain, however, it may accept extraterritoriality in exceptional cases. The contentious issue at hand is whether the applicants can appeal to the court, even though the acts occurred outside of Italy's, or in fact any state's, territory. There are 2 concurring precedents in ECtHR case law. The first one is the case Louis II vs. Turkey of 1995, where the applicant brought action against the expropriation of his estate in northern Cyprus upon Turkish occupation of the area. Here the court found that responsibility of a state may arise when it exercises effective control of an area outside of its national territory. In Bankovic vs. Belgium of 2001, a case which concerns the killing of civilians during operations of NATO in Serbia in 1999, this view was however revised, as the court argued that sporadic acts outside of the territory do not fall under its jurisdiction, since there needs to be a structured relationship of the act to the national territory. Moreover, it was held that the European Convention on Human Rights, as a regional instrument, was not designed to be applied around the world. In the present case, the court sticks with the former precedent, stating that Italian forces exercised effective control over the applicants and were consequently responsible for respecting their rights under the Convention. This argument was further supported by the reference to Article 92 of the United Nations Convention on the Law of the Sea, which stipulates that any vessel carrying a flag is under the exclusive jurisdiction of the respective flag state. The argument is even stronger due to the special status which is accorded to warships under UNCLOS. In fact, it seems logical that state parties to the convention should be bound to respect human rights anywhere in the world and for any person under its effective control. It seems intolerable that human rights violations carried out by states which would be illegal in Europe should be permissible once outside European territory.
The court's ruling is not only groundbreaking in terms of admissibility criteria and establishing jurisdiction. Further, it is worthwhile to review in some detail the material ruling of the court in response to the Italian government's arguments. The Italian government argued that the applicants had not proved in an adequate manner that they had been subjected to treatment allegedly in contravention of the convention. Further, the Italian government highlighted that Libya can be considered a safe host country due to the fact that it ratified the ECtHR, the Convention Against Torture, and expressly undertook to comply with the principles of the UN Charter and the Universal Declaration of Human Rights in a treaty it had signed with Italy. On the contrary, the Strasbourg court found a violation of Article 3 on a double count. Firstly, the court ruled that due diligence has to be observed. The Italian authorities knew or should have known that as irregular migrants, the applicants would be exposed in Libya to treatment in breach of the convention. Secondly, the court found a violation of Article 3 on account of the fact that the applicants were exposed to the risk of arbitrary repatriation to Eritrea and Somalia. In regard to this, the sole existence of the risk of repatriation at the time of the return mattered. In other words, the court established the acceptance that a risk of violation of Article 3 exists without requiring that it be proven beyond reasonable doubt. For the first time in its history, the court examined Article 4 of Protocol No. 4 applied to a case involving the removal of aliens to a third state carried out outside national territory. Neither Article 4 of Protocol No. 4 nor the travaux préparatoires of the Convention precluded extraterritorial application of that article. The court reasoned that Italian authorities had neither subjected the applicants to an identification procedure nor carried out any form of examination of the individual situation of the applicants before returning them. The government stated that the contested event had taken place on board ships and therefore it had been impossible to guarantee the applicants the right of access to a national court. The court ruled that exactly these circumstances represent a violation of Article 13 ECtHR. The applicants were all returned to Libya without Italy having given them access to an effective asylum procedure conducted by a competent authority or, a fortiori, any procedure which would have checked the legality of their removal more broadly. The findings of this ruling greatly enhance the legal protection enjoyed by migrants and refugees en route to Europe. If its findings are upheld in subsequent rulings, it could serve as a valuable basis for addressing crimes committed during the crisis of the European asylum system since 2015.